the death of MV. In exchange for guilty pleas to those 2 counts, the state would move to dismiss counts 1 and 2 and recommend 10 years initial confinement, which is the maximum on those 2 Class G felonies. The defense would be free to argue. Would the court like a more record today about the reason for this amendment?
Yes, I mean, I know you've done it in the past, but if you could, yes.
Sure, Judge. As the court knows from our past discussions and from the complaint, as stated, this is an extremely serious case where the defendant's car was traveling at an incredibly high rate of speed, hit the victim's vehicle, who was, I believe, making a turn, killing both the driver and the passenger of that victim's vehicle. Normally, the result of a case like that would be far more significant, and I think in line with some of the things the court suggested at the first date. However, in this case, I think the circumstances are very unique. As I think accurately detailed in Ms. Tate's filing before our last court date, there was a significant amount of corroboration to the idea that the defendant was fleeing from a man who may have had a gun in this case. Ms. Tate, as I said, accurately laid out the 3 or 4 pieces of evidence that corroborate that: statements from the defendant, statements from his passenger, statement from an independent witness who was at the previous stoplight, saw the man approach the defendant's car, didn't see the gun, but definitely saw an angry confrontation between someone. And finally, the surveillance video that shows the crash, so shows a chasing type vehicle that fits the story provided by the defendant, go through the crash scene also at an extremely high rate of speed a few seconds after the defendant and the crash happens. Based on all that, Judge, the state believes that in exchange for immediate acceptance of responsibility, this was initially discussed as a negotiated issuance, and then Ms. Tate convinced me to re-extend it, assuming that the defendant pled right away, which he's always been in a posture to do or wanting to do. So assuming that immediate acceptance of responsibility, the state felt that the 2 negligent operation of a vehicle charges were adequate, kind of balancing the idea that, yes, in this case, because of those odd circumstances, the defendant did have a reason to be going faster than normal, but that the speed he ended up achieving was just not even proper or legal, even under those circumstances. So we've tried our best to strike a balance the state believes that we have with this result.
All right, for the record, I am live streaming this. It's on YouTube, and so the victim's family can be watching now, or I'll leave it up for roughly 24 hours for them to view it later. I presume the state did discuss this with the victim's family, correct?
We did, Judge. We discussed it. And the victim's family is always a somewhat difficult thing to define. We were always had a point of contact with, I believe it's the victim's daughter. We discussed that with her prior to making the negotiated issuance offer, and again at the point when we were discussing whether to re-extend it and slightly elevate it, which we did. The victim's son did show up to that initial in-person date where the court first expressed concerns about the results. As we left the courtroom, he expressed to me some unhappiness with it. But throughout this, I believe—
Hang on. My court reporter just lost her connection. All right, give me a minute. She needs to log in again. Somehow her connection was lost. right. Hopefully my reporter is coming back in. Carol, before I go back on the record, can you tell us what you last heard or when you got knocked out? Carol, can you hear us? All right, my reporter just sent me a text that she can hear us, but at the moment can't unmute herself. So, Mr. Shinholm, I'm going to ask you to back up to notification or conversations you've had with the victim's family, please.
Sure, Judge. We discussed the victim's daughter has always been our point of contact. We discussed the negotiated issuance idea with her before I extended that to prior defense counsel. And then again, it discussed the slightly raised offer, which is what Ms. Tate convinced me to re-extend after the case was issued. She's always been agreeable and thought that was a fair result. The one detail or caveat is that the victim's son appeared at our first in-person date where the court expressed concerns about the negotiations in this case. After hearing that from the court, I talked to him and he had some concerns which he expressed to me. I just, in our little break here, while we were waiting on the court reporter, called my victim witness advocate and double checked. And she said, she informed me and confirmed that since that time and before today's date, we've had repeated discussions again with the victim's daughter, who confirmed that she spoke to her brother, and the family's all on the same page and not objecting to the way this case is resolving.
All right. I mean, obviously I made a record on this previously. I mean, my concern at probably 2 months ago now, approximately, when it was initially presented to me was that, I mean, every case is different. Every case has its own set of circumstances. Every defendant is unique and has different circumstances. But as Mr. Shinholm certainly is aware, and as Ms. Tate is probably aware, I mean, in situations where 2 people are killed in a driving homicide, I mean, you're normally looking at a sentence in the 20 to 30 year range. I mean, each case is different. Again, but I know myself, those have been sentences that I've imposed in very, very similar cases. And the gravity of this offense, killing 2 people, is off the charts in terms of the gravity of the offense. I mean, it's as bad as it gets. Now, Ms. Tate did an admirable job of explaining the circumstances, and so I'm willing to accept the plea given everything that Mr. Shinholm indicated on the record and the Ms. Tate provided in writing previously. Ms. Tate, your client's ready to proceed?
Yes, Your Honor.
Mr. Valdez, you understand that in this case, first of all, you've heard everything that was just discussed for the last 5 or 10 minutes. Is that correct?
Yes, sir.
And you understand that the state is making an amendment or a modification of the charges in this case, and you're charged now with 2 counts of homicide by negligent operation of a motor vehicle. You understand that?
Yes, sir.
And what's your plea to those 2 charges?
Guilty.
The plea paperwork, the plea questionnaire, which was filed with the court, indicates that you are 19, you've completed high school, you obviously understand English, correct?
Yes, sir.
Judge, if I could just really briefly interject, Mr. Valdez has turned 20 since we filled out those plea forms back in May. So just, if I could just orally correct that on the record, he is now 20 years old.
Mr. Valdez, that's correct.
Yes, sir.
The plea paperwork indicates that you understand the charges. Both of these matters are felonies. They're obviously both homicide charges. They're both obviously very, very serious. You understand that?
Yes, sir.
Plea paperwork also indicates that you've not used, and the paperwork was filed some time ago. So I'll ask you if you've used any drugs, alcohol, or medications in the last 24 hours.
No, sir.
By proceeding today, by pleading guilty and admitting to these two crimes, you're giving up certain constitutional rights. You're giving up the right to a trial. You're giving up the right to remain silent at a trial. You understand that?
Yes, sir.
You're also giving up the right to a jury trial where 12 people, 12 citizens would have to agree that you're either guilty or not guilty. You understand?
Yes, sir.
You're giving up the right to call witnesses. You're giving up the right to cross-examine any witnesses that are called against you. You understand that?
Yes, sir.
Ms. Tate, you discussed with your client the elements of this offense. You attached, I believe, the jury instruction. Is that correct?
Yes, Judge.
Mr. Valdez, you've discussed with your attorney the elements of this offense, two offenses, two charges of homicide by negligent operation of a motor vehicle. Is that correct?
Yes, sir.
Mr. Valdez, you understand that in each case, the maximum sentence is 10 years in the state prison system, 5 years of initial confinement, 5 years of extended supervision, or the fine of up to, or a fine of up to $25,000 on each count. You understand that?
Yes, sir.
And you're facing a maximum of 10 years of initial confinement and 10 years of extended supervision and a total possible fine of $50,000. You understand?
Yes, sir.
On page 2 of the plea paperwork, there's some things I need to discuss with you. First of all, I'm advising you that if you are not a citizen of the United States, pleading guilty, admitting to this crime could result in various penalties under federal law. These penalties include deportation. You understand that?
Yes, sir.
You understand that because this matter is a felony, because of these charges and these convictions, you'll not be allowed to vote in any election until your civil rights are restored. And it will be unlawful and illegal for you to own or possess a firearm, a gun, at any time ever for the rest of your life. You understand that?
Yes, sir.
You understand in this case that the state's going to recommend 10 years of initial confinement. That's basically the maximum sentence, is the maximum sentence on initial confinement, and not take a position on the extended supervision. You understand that?
Yes, sir.
The plea paperwork indicates that you are pleading guilty freely and voluntarily. Is that correct?
Yes, sir.
Has anybody threatened you to plead guilty?
No, sir.
Anybody force you to plead guilty in any way?
No, sir.
Anybody promise you anything to get you to plead guilty?
No, sir.
And in the plea agreement, the state's going to recommend 10 years of initial confinement. Your attorney's free to make an argument, but you need to understand, Mr. Valdez, that this is a prison case. You're going to prison. You understand that?
Yes, sir.
I mean, there's no doubt about that. There were 2 people killed. I'm sure Ms. Tate is not going to suggest anything less than some sort of a prison sentence. 2 people were killed in an extremely reckless situation. You understand that?
Yes, sir.
And I'm sure that's extremely uncomfortable for someone your age, but that is what it is. You understand?
Yes, sir.
It appears you signed the plea paperwork. The plea paperwork was actually signed as I reviewed it in May. I'm sure you've discussed this matter multiple times with your attorney. Is that correct?
Yes, sir.
And you're pleading guilty freely and voluntarily. Again, is that correct?
Yes, sir.
You've discussed this matter. You've reviewed it. You've gone over it with your attorney. Had enough time to discuss it with her. Is that correct?
Yes, sir.
Ms. Tate, you went over the plea paperwork with your client?
I did, Judge. We reviewed it in May and we reviewed it again this week.
You believe his plea today is free, voluntary, and intelligent?
I do, Judge.
And you saw him originally signed and dated in May, and again, as you said, you went over it with him again recently, correct?
I did, and I provided him copies of all the documents as well.
All right, I've read the complaint in this case. Obviously, both sides are stipulating the facts in the complaint or a portion of the facts to support the two amended charges and the pleas. Is that correct?
Yes.
Yes.
All right, based on the stipulation, based on my reading of the complaint, based on what's been indicated in court by counsel and the defendant, I'm finding a factual basis exists for the charges of and pleas to two counts of homicide by negligent operation of a motor vehicle. I'm finding the defendant's pleas are completely free, voluntary, and intelligent. And based on those pleas, I'm finding the defendant guilty, ordering convictions and judgments of conviction entered on the record for the two amended charged offenses. The defendant has obviously been out of custody. He's been cooperating with the out of custody rules. We'll set a sentencing date. Ms. Tate, how much time do you need or want?
Judge, I do plan on ordering a private PSI, so if we could have about 60 days in order for my writer to complete that.
Sure. I'll have my clerk look for a day. I have a couple of trial weeks in mid-October, but I'll have my clerk look at maybe, for instance, October 15th, maybe.
Okay. And Judge, just for the record, were counts 1 and 2 of the amended information dismissed and read in?
I don't think I said that, but that was part of the agreement, Mr. Schindhelm, correct?
Yes, Judge.
Yes, they are dismissed and read in for purposes of sentencing. That was part of the plea agreement. It was part of the discussions and negotiations between the parties. And I had been advised of that as part of the plea negotiations previously. So yes, counts 1 and 2 are dismissed and read in.
Thank you, Judge.
Judge, you are in person on the 15th?
Well, it's the end of my trial week. So yeah, as far as I'm concerned, I am.
Okay.
That is my trial week, right?
It is. Is that 1:30 on the 15th?
Thank you. Yeah, whatever works, if it works for the lawyers.
I can do that if it works for the state.
That's fine.
The next court date will be October 15th at 1:30 for sentencing, room 423 of the safety building.
Thank you.
All right, I think we're adjourned for today. Anything else in the state?
No, thank you, Judge.
Ms. Tate?
No, Judge, thank you.
Obviously, Ms. Tate, I'm sure you'll advise your client that among the many, many things I'm going to take into account, we get to sentencing in 2 months, will include his behavior while he's out, correct?
Absolutely, Judge.
All right. We're adjourned for today. Thank you.
Thank you. Anthony?